respected regional council member, and more my dear friend Ketan Bhai, Ridesh Bhai, regional council member, and Jinet, my colleague and dear friends. Uh, First of all, thanks to WRC for having given me opportunity time and again. The introduction of Ketan Bhai was more out of friendship. You know, the friend always ignore your failure and appraise your success, whether it is or no. Ketan Bhai is more on that side. Of course, we have worked together, and by and large, let me tell you why is appreciation. As you grow, I'm 60, so I have committed more mistake than what you people have committed, and I have perhaps learned more out of that. So nothing great about it. I'm sure all of you have a competence. It's a matter of time. Uh, First and foremost, the big compliments to the team who has structured this course, the litigation series 2 days course. In fact, Jinit was interacting with me when I was invited on behalf of WRC for this, and we have a lot of interaction. I know Jinit for quite long, and in fact, let me tell you, the WRC newsletter, the GST update, we were compiling together for last couple of years. So I learned a lot from him on that front. The lot of thought process he has put, because from pin to pen he was wants to cover within these 8 sessions, and at the end of the day you must have seen the structure, because there is always a limitations, like we are watching IPL. So you may be the best of the performer, but you get only 4 overs to ball max, and you get maximum 20 overs to bat. The same thing is over here. The topic given to me is quite vast. I can understand the idea is to give more to the participants within limited time, but it's a challenge on the other side for me to ensure that I come up to the expectation of the organizer. So with that, I will try my best to give justice. The the as the heading you can see, it is a practical aspect of appearances. The word practical is very dangerous, because that you know better than me, on the contrary. Because for practical part, you may not be knowing law. Sometimes those who don't know the law are better in practical front. And the other part, appeal to commissioner, yes, the provisions, etc. are concerned. I'll able to tell you to the best of my knowledge and the understanding. And what all I try to do in the department when drafting and appearance, etc., I will share my thought process on that part. So, considering the topic per se, I'll not try to explain you the basic provision. But what I have done is I've made some case studies, and through the case studies, I'll try to explain the provisions related to appeal. So, the forms, timelines, delay, condonation, etc. And then some of the decisions which we have currently on the GST front, some of the decisions in the old service tax excise law, from where we can draw the analogy, because the provisions are concerned by and large for appeal are concerned are picked up from excise and service tax. So many of those precedents will help you out. And the practical tips which I have to give as per the organizers thought process, that I will share on some of point. Let us make the session interactive. But let me tell you one thing: 57 slides, 90 minutes. I don't know how far we will reach. So if you are asking or interacting, please stick to the topic to the extent. That's the only part. Is my request is. With this, let us start the process per se. See, first of all, one more thing: the appeal procedure part on the portal and all, although it is covered in my notes, I have shared, but that I'll be skipping. I've been told by organizers there is no need. Basically, by and large, all of them can teach you how to file the appeal. So that part I may not be taking it. Well, the relevant sections of the appeal is concerned, by and large, I'll be dealing with the first appeal. The tribunal, as on today, has not seen the light of the day. So only 1 or 2 slides about the tribunal, what all information we have. So these are the few provisions related to our appeals are concerned, and the relevant forms which you come across while filing the appeal. Very few forms, but whenever there is a few, there is a lot to understand, and that one has to keep back of the mind. So with this, we'll start with the case studies. I'm sure you the structure when I have seen the summons, show cause, all those were structured, but in the order actually, unfortunately, for whatever reason, the appeal has come first. That is the limitation of the organizer. Otherwise, the whole process will be investigation, summons, show cause, and then comes appeal. But anyway, so that to that extent, we will have car tired of bullock for the time being. There is a company called ABC who got an SCN DRC01. Please, while going through the case study, mark the dates, because everything is rotating around the dates. So, and I'll not be able to go back to all the old slides. So, please take note of the dates. So, ABC was served with the show cause in January 24/13. The show cause was reply filed on 9 February. The learned officer has upheld the demand. 1st March 24 was the date of order, and which was served on email on 18th March. See the dates. Normally the flow goes like this only in the real life also situations. So these are the 4 date: SCN, reply, date of order, and then email. You got from email on 18th March. The next is order was also sent by post on 18th March, and it was received on 25th March. So that is a transition time. The order was uploaded on the portal on 20 April. So all the three events are happening in this. You get by email. Assume that it has come on the official email ID of the assessee, which is there on the portal. It has gone to a correct address. It was posted, and thereafter it was uploaded on the portal. With this background, the issue is appeal against said order lies before which authority? First of all, what is the authority? The order was passed by Assistant Commissioner. So that just for your refreshing yourself. And second, whether appeal to be filed manually or electronically. That is the second part, because the order has come in 3 different modes. And the last is what is the due date of filing the appeal in this case. These are the 3 issues basically. If somebody would like to share, I'll be glad. Giving reply one-way traffic, I think we may not be. In fact, let me tell you, I learn more than you when we are sitting in such type of conferences. Always speakers learns more. So anybody would like to say, first of all, against which authority appeal will lie? Assistant Commissioner passing the order. Appeal will be lie against which authority? Sorry? Commissioner. Okay. Anybody else? Fine. The second is about the whether it is filed manually or electronically. I think a lot of people. Somebody can raise the hand. Yes? I have to file both. So suppose I file upload today and file tomorrow. What is date of filing? Achha. That is copy or to submit. But filing of the appeal is both or anyone or only electronic or only manual? Electronic only. Okay, fine. All of you agree electronic only. Fine. And what is due date of filing the appeal? Okay, due date 3 months I know. Sir, in this case 3 months starts from when? Sorry sir, one by one. Sir, actually this is a live case study of my client. I charge the fees. I have to give opinion. I don't know the answer. That's why I am getting from you. So you tell me. Yes, one by one. What is due date? Can you, somebody can raise the hand and then, yes, what is date? 24 June. So how you have counted 3 months from which date? So 25th March according to you. So he is going by that postal order. Okay. Any other answer? Little louder. April. So you go by email. Sir, this is that. For email on 18th March. Portal is concerned 20 April. So 3 months will be July. 19 July. Okay. So he is with post. He is with the portal. Anybody else? Now only one left out. Yes. June. So anybody says email is also delivery. So then all the 3 modes come. Which one you have to follow? First one. First one. So first is the email. Okay. So we'll go by email. Majority says first is email. Correct? Fine. Good one. I was also confused. So let me see what provision says. So first is about the authority. Now let us see the section. Person agreed by the order of adjudicating authority. The word is a proper officer and adjudicating authorities. Okay. The adjudication is done by either of these 2 authorities. One is a additional commissioner and joint commissioner, or second is a deputy assistant or superintendent. These are the only 5 people they will be doing your adjudication. Exceptional cases where there is a principal commissioner and all. That's a different issue. So in general cases, 99% these 5 people will only do the adjudication. Your order will come signed by these people. Okay. So in the law, they have put in 2 baskets. So additional and joint commissioner is a hierarchy which is higher, and deputy assistant and superintendent is comparatively lower hierarchy. That is based on the financial taxes involved. They have segregated based on that. That is in the law. Now I think the one who will take up show cause notice will take you through those provisions. Now for our understanding, there are 2 baskets. Now when you are filing the order, In this, our example, I told you it is the assistant commissioner who has passed the order. Correct? So we'll fall on the right hand side of this bracket. But suppose it is an additional commissioner, the appeal lie before commissioner appeal. They call it commissioner appeal, CGST, such kind of designation they give it. But when it is passed by assistant and deputy commissioner, it will be an officer not below the rank of joint commissioner. So it will be joint commissioner, equivalent or higher. It will need not go to commissioner, first of all. So almost all the time when you see your order, they will mention that file appeal before joint commissioner. In rare case, I have seen it is mentioned as additional commissioner also, because it is so. In our case, it is a joint commissioner. You will always find that in the order in original on the first page, you will find they will mention, if you are aggrieved, please file appeal before this authority. You have to read it and accordingly you have to file it. But in our example, I say that it is joint commissioner or equal to anybody else higher than that. So it will not be commissioner, it is joint commissioner. Unless order mention that commissioner, which I have not seen it so far so good. The time limit is 3 months, but 3 months starts from where? From the date of communication of order. That's a big challenge, how to interpret communication of the order. That is what the provision which is used in section 107. Now, in the instant case, the appeal, this I have cleared joint, we have received the delivery of order in all the 3 modes. There are 6 modes prescribed in the law. So, other 3 modes have not yet come. But these are the 3 modes we have taken. So, how to calculate the 3 modes? Now, for that, you go to section 169, which says that service of notice of order. In our case, it is an order. So, we'll stick to order. Now, what are the options given in the law? 169 gives there are 6 modes through which the order can be served on the assessee. That is what first is the tendering or couriering. Tendering or couriering. In the old days, couriering was not there in service tax. Now couriering is allowed. Of course, it comes by register post or post office by and large, but couriering is allowed. Now, first of all, tendering and couriering to the addressee, that is one, or the taxable person. What is the difference between addressee and taxable person? Addressee and taxable person. Is there any difference or no? So what is a taxable person? Registered person. Then what is addressee? So there may be a possibility the person is not registered and department want he has to pay the tax. And for that litigation started and appeal that, then he becomes an addressee also. So he need not be a registered person. The third is a manager. This is where you have to be very careful. The law itself says that the department can serve the order even to the manager, authorized representative, advocate, tax practitioners holding proper letter of authority to appear in the proceeding. That means suppose you are chartered accountant, you have appeared for show cause notice and in the hearing of show cause notice, and your name and authority is appearing and the order is served to you. The client cannot take a plea that it was never served to me, because law says even to the authorized this thing, unless and until you mention in the authority letter that it is only for the purpose of drafting the reply and appearance the authority has been given, nothing more than that. If you don't mention that he is also there, these are all very dangerous. Be careful, because we have come in our office kind of cases where the CA is not at good term with the assessee later on for whatever reason, and order is served to him, then there are always a problem. So you have to be very careful to that extent. The next is person regularly employed. So even peon is also regularly employed. The office of peon may be there for 30 years, 20 years. So can you serve to him? How to interpret the employee is a question, but in my view, it will be only one which is related to taxes and accounts. One has to understand. If you send it to marketing guy, so he will throw in dustbin. Okay. The next is to any audit adult member of the family. See, be careful. Adult member of the family. This is very, very wide. So if there is a partnership from 6 partners, सबका family किसके पास भी जाएगा? So one partner may be looking after only sales or purchase. उसका family, तो he may not be knowing partner क्या business कर रहा है. But then this is what, how to interpret all those issues will come. But right now I may not be taking every issue, but you should know the provisions, that what are the power, GST, the scope, coverage, everything is very, very vast. And this will give leverage to department. They will be able to say, I have done it because section 107 permits. Okay. Then the next is mode is registered post, speed post, courier with acknowledgement due. It must be acknowledged. So that is one part. To a person to whom it is, for whom it is intended. That means basically the assessee one, because to it is always to assessee or a person against which there is a proceeding. So that is one part. or his authorized representative. This is second mode. So there are 6 modes I told. So this is a second mode of delivery, service rather. The third is at his last known place of business, because your address may keep on changing. So whatever is known to department, at that address only they have to serve as per section 107. If it is written back, don't worry, because then it is not acknowledged. The word is written with acknowledged you. Okay. The third mode is registered email. Registered email is very important. Whatever you have written on the portal, so be careful. पोर्टल के ऊपर एक ईमेल लिखता है याहू देयर आफ्टर यू गो टू जीमेल व्हाटएवर okay, so that you have to be very very careful. You have to keep updating the information from time to time. Uploading on common portal, of course, that is a fourth mode. The fifth mode is a publication in newspaper. I think these are all the extreme stages. Okay. And the last is affixing in the conspicuous place on the notice board of the office of the concerned officer. So if you are absconding, etc., not traceable, those scenarios, then the adjudicating officer who has passed the order outside his cabin, many a time you will see there are some orders are affixed. Those are those guys. So they're Vijay Malak type of person. So those guys will be orders will be there. That is also a mode of delivery. So these are the 6 ones. Now the question comes, is it all the 6 modes, any one out of 6, or in the order of preference? How to do it? So if you read the section, it is any one of the 6 modes prescribed. The department, the officer can deliver, serve the notices to you. It need not be in the order, but generally, logically, the last two, newspaper and the affixing is very very extreme case may it is resorted to. Otherwise the first 4 modes generally happens, but it can be any one of the modes. Now wide coverage as compared to the old regime of excise and the provisions which was made applicable to service tax. Going by this provision, in our case, in our example, it is the 3 modes. First started with email, then we got post, then it is portal uploading, which are all the authorized mode as per section 107. So can you not say that when the first mode, if it is sent by delivery, that is the date of service of the notice, because that was permitted in the law and which is done. If somebody is sent second time, third time, it is out of precaution, abandoned precaution, or whatever it may be. Okay. But from your perspective, it is the first date. So your 3 months time, strictly as per section 107, will start from the day on which the email is served in our example, which is the first. Okay. I hope it's clear on that. Okay. The law has kept on changing from time to time. So the position, if you ask me what was there in 18, 19, 21, 23, so I am telling you this is the position today. Okay. Because बहुत डिफिकल्टी से इतना याद रहता है. तो 23 में क्या था, 22 में क्या था पूछेंगे तो ये भी भूल जाएंगे. ठीक है. The law is fast like a FMCG product. So now the question is, there are few amendments relevant to it. The very first is on 4th of August 23, which is relevant, and it is rule 108 subclause 1, which is talking about it has got connectivity with section 169 about the communication of the order or the service of the order. What this rule says: an appeal to appellate authority under section 107 subclause 1 shall be filed in form number so and so APL 1 along with the relevant document, either electronically or otherwise as may be notified. So first is electronically or otherwise notified. It has to be notified by whom? By commissioner. Now there will be so many commissioner. So for every state there is a different commissioner. Which commissioner? So it is qua state. If you have got Gujarat, Maharashtra or Rajasthan, so whichever state commissioner notified, that will be applicable to that state. Other commissioner not notified, that provision is not applicable. There is a one of these such commissioners circular I will give you in the next slide, that is Orissa. Or manually. But manually is only when appeal cannot be filed offline due to non-availability of the order on the portal. So now in our example, order is there in soft form, in hard form, and even on the portal. Okay. The rule 1081 is on from 4th August. So today we are bound by this rule 108. Okay. Now in that case, it has to pay by either this, or either this. Going by this, if you say me how to file the appeal, if you strictly read this part of it, then I will say it has to be filed electronically only, because manually is allowed only when it is not uploaded on the portal. In our example, it is already uploaded. I have stated. Okay, one part of it. And when it is to be uploaded, on the due date when your appeal falls due. So in our example, after email 3 months, my appeal is falling due. And at that point, it is there on the portal. So appeal has to be filed electronically. But suppose you are very proactive and you got me email and the next day you filed the appeal. That day it was not there on the portal. You got my point what I'm saying. So you got on 18th March something whatever date and you are very fast. Okay. So you prepare the appeal next day and there is nothing on the portal. Then physical will be permitted. Because then there is no normally it doesn't happen. I think so. हम लोग first day always last date पे रहते हैं. But anyway, but as far as the provision is concerned, this is what the situation. Okay, and provided it is not notified in Maharashtra, Maharashtra there is no notification. We are only talking about Maharashtra. So Maharashtra Commissioner has not yet notified any other board. So for Maharashtra, there are only two more as on today, which is known to me. There may be circulars coming left and right. These two experts are sitting here, so if I missed out, they will correct me to that extent. Okay. Now here is the one of the circular notification that is from Odisha state, and I have given the reference of it. It was issued in March 10, 2023, where in that particular state they have given a guidelines of filing the appeal manually. Now, if you look at the date, this is 10th March 23, and this rule was amended on 4th August. So before amendment of that rule, this notification was there. Got it? No, this rule has given three options in scenario, but when this rule was not there at that point of time, this in Odisha state it was notified. So for Odisha, it is either electronically or the mode prescribed by the commissioner to that extent. I hope it's clear. Now there are decisions to it. Uh, please don't take this decision as it is when you are replying to somebody, because you look at the situation, rules, laws, and the facts of the case at that point of time. The decision comes in 2020 and the facts will be of 2017. And the provisions were also something different. Circular is also different. Rules will be different. So, एक ही सर्दी का एक ही दवा नहीं होता है. The cause of the, you have to see what is the cause. Otherwise, there will be only one standard medicine and you take it, no need to go to doctor. ऐसे नहीं होगा, so be careful on that. Now, this is one of the decisions of Gujarat High Court in the case of GSP, Gujarat State Patronate, where it has been held that filing of the appeal and uploading of the order are intertwined. So, the uploading and filing is connected, intertwined. That is the activities they say. This is before that amendment, because this was pronounced in 2020 and the rule came in 23. The order is required to be uploaded online. See, because that time it says that it is mandatory you have to upload on the online, so that the appeal can be filed electronically as per the mandate of the provisions. So 107 vanilla says that you have to file online only, erstwhile. However, there is no provision or procedure to file appeal manually. This is at that point of time, there is no commissioner and all those portions were not there. In such circumstances, there was no failure on the part of the petitioner to file an appeal within prescribed time of limitation, as the period of limitation did not start till the order passed by the adjudicating authority was uploaded. In the fact of this case, what has happened is order was served otherwise than uploading on the portal, and there was a delay, and that's why I say the law बोलता है upload करो. You are not uploaded the portal, so I cannot file the appeal, so my limitation cannot start. In that scenario, this decision has come. In our example, this will not be hit because it was uploaded on the portal. And plus, our example is in an era where there's a rule was amended to that extent. This was in an era when there was no such amendment in the rule giving the option. But this year's decision is there, and it has lost its relevance that I have written below after 4th of August, especially. The next is Andhra Pradesh High Court decision. Just why I'm drawing the attention, if somebody's matter for old period is pending, no, you can take advantage of this year. Only thing, that's why you try to apply. There's nothing wrong in copy paste. Okay, thing, but only you should know what to copy and where to paste. Okay. The next is of Andhra Pradesh High Court, Navya Food. The appeal is required to be filed in electronic mode. This decision came in 22, again before that amendment. And any other mode is prescribed by way of notification. That is about the commissioner. There is nothing on the record to show that any notification was issued prescribing any other mode. Means Andhra Pradesh Commissioner has not prescribed anything. So it has to be by only mode of portal, uploading on the portal that time. Therefore, the argument of the petitioner that the time period for filing appeal would start only when the order is uploaded on the portal cannot be pressed aside. That is right. Because law said you have to upload. upload the order, and then only appeal has to be filed. Manual tha nahi, commissioner ne prescribed kiya nahi, and that's why the delay was condoned. There is no question of delay. This has also lost the relevance after 4th August. The next is adjudicating officer. What is his role? When he passes the order, he has to upload the same on the portal. It is mandatory for him to do it. There is no option. He has to do it. File appeal electronic once it has been on the portal within 3 months. So when the order is on portal, you also upload on common portal only. And normally if an order is there on the portal, then only portal allows you to file the appeal and make the pre-deposit, etc. Within 3 months from the date of communication of order. Communication, I think I have explained you, 169 section. 3 months from the date of upload on the portal in this case, because when you are referring to this, okay. The next is, if it is not uploaded on the portal, nowadays there are few issues, few instances which we see. By and large, everything, by and large, I say, are uploaded on the portal. But only thing, it happens on a different date, and that causes the problem. So I would like to put it this way, that when you are uploading on the portal and that time order is there, please ensure that you count your dates from the first date of service. Although portal may later it has come, because today's time, no, the fighting the war may be easy, but nobody affords it, the cost. The same thing is litigation. Except you, nobody earns. Okay, so that is the only reason. Now it is up to your choice. It's always pain for client. So be careful to that extent. Avoid the litigation wherever possible. So state in which commissioner has notified, then you follow that. Maharashtra said, I have not come across. So file the appeal within 3 months from the communication of state notification, or state in which commissioner has not notified, then you have to file electronically only. And there is a circular to that is post 4th of August, and there is a circular in Maharashtra that the hard copy thereof has to be submitted within 7 days. That circular says that if you don't submit within 7 days, it will be treated as not filed. That is a ridiculous thing. What circular? There is no such law. Circular is saying that give a hard copy is a facility. Bloody, I cannot file appeal twice. You know, this is nonsense. Circular which is contradictory to law is not valid. So I have seen many of the officers says that तुम्हारा appeal time में नहीं है, although it is there on portal, physical copy नहीं दिया. But I'll tell you again, no, the fighting the war is concerned. Even if you win, no, there is a cost. So please avoid that. Try to do it within 7 days. But if you have not done it, don't worry. It is not that you are lost. But let us try to have a discipline to the extent in the interest of the client. Okay. The next is Andhra Pradesh High Court in the case of Lakshmi Venkateshwara State. This is 2021 decision. It is held that this is very, very interesting. You need to file the appeal 107 provision, service of notice 169. Then there is a section rule 26, which is very, very important, and which says that, now this decision if you read, then I'll explain you that relevant part. It says that there is a rule 26 CGST rule subclause 1 specify that all the application including appeal which are required to be submitted under the provision of this rule shall be so submitted electronically with a digital signature or through e-signature or verified by any other mode of signature or verification as notified by commissioner. So the different modes where there is a Aadhaar based electronically, that is EVC we call it as, or there is a bank account based one time password OTP. These are the modes which has been given, and this is as per the notification number 6 of 2017. Now rule 26 is there right from that date till today. So that means what it says, that appeal is concerned, all the communication application including appeal must be signed digitally on that mode only, and this rule remains intact. It is not amended, not override, nothing. Now based on that, what happened, there was an argument saying that if I have to comply the law, I have to comply the law as a whole. So you say something 169 may delivery, 107 may how to file the appeal within the time limit, commissioner notified some mode, everything is fine. But what about rule 26? 26 says that you have to authenticate digital signature, and that has to happen of the or when you file the appeal. It is mandatory. So how can I do it unless it is uploaded on the portal? See, somebody gives you physical copy, then you cannot file appeal on portal. So how you will digitally appease then all this thing on the portal? Not possible. So that was the argument taken. And there, that means there is an anomaly between the act. So 107, 169 and this 26 rule etc. is concerned. So therefore, the Andhra Pradesh High Court held that apparently there is a discrepancy between 108 and 108 subclause 1 and 2. By virtue of that, this rule 26 has come with regards to manner of filing the appeal. See, one is where to file, when to file, how to file, which form to use, but how to authenticate is also part of filing. You have to do everything, then only appeal can be filed. So there is an anomaly. And in view of that discrepancy, the benefit should go in favor of assessee. And the appeal time is concerned, there is no delay. This is what has happened. Now, for your this thing, today also Rule 26 persists. So if you are stuck somewhere, and if you can prove that I cannot upload the appeal because of XYZ limitation, and I cannot affix digitally or with the help of this Aadhaar based CVC, etc., then you have a good case only on this ground. This is Andhra Pradesh High Court is concerned. You can take advantage. But I think recently, after this 23rd of August, etc., these kind of situations I have not come across. But somehow, if you have come across, you can take advantage of this decision. These are the further observation. I think since I have explained, I will not read it out. These notes I have already given to the organizers, and the whatever mode in which they want to convey, they will forward. So no need to take photograph. I think you are going to distribute this. Then other uploaded on the portal. You can download. Same note I will be giving. The next is service of order. Now this service of order 169 1 was there, then 169 2 is there, which is very important. And there's a deemed service. Now you try to understand the within the section there is an anomaly. 169 2 and 7 which provides for that the order shall be deemed to have been served. So it's a deeming provision. What is the service is in 169 1 and what is meant by deemed service is 169 2. Okay. On the date of its tender or normal period taken for such tender to be completed unless proved contrary. Okay. Now, what is that subclause says? Every decision, order, summons, notice, communication shall be deemed to have been served. Okay. On the date on which it is tendered or published or copy is affixed. That now in our case, publish and affix chhod do, but tendering is there. That means I have given in post. I have given on email, I have shoot the mail. So these are the date on which I have tendered because post is the agency of receiver, not giver. So as an officer, when he has a proof that I have tendered today, you may get delivery tomorrow, day after, or maybe after a couple of days. Okay. But from his side, no, he has tendered today. That is what, because post is a receiver's agent and not the sender's agent. And subclause 3 says that when such decision order, summons, notice, or any communication is sent by registered post or speed post, it shall be deemed to have been, and there they have used the word received. So in section 169, they start with service of notice as a heading. When they are talking on 169 2, they say deemed to have been served. So that means correct. Service may deemed served. But when it comes to 169 3, it is deemed to have been received. Received is not important at all because it is date of service which we are looking forward for and not the date of receipt. I hope you are getting what I am trying to say. If Ginit serves the order as an officer to me today, and if you go by the provision, you will read service. So he has either sent by email or post. Email, so it comes immediately. It may go into your whichever box. That is okay. But he has served. But suppose he has sent in a courier or post. So his job is over. It is being tendered today. And it is deemed to have been served on the date on which he has tendered. So from me it will become today. And if I receive after 10 days for whatever reason, then 169.3 says that shall be deemed to have been received, which is not relevant for the purpose of this thing. So there is an anomaly between 169, 2 and 3. I hope you are getting this. They should have written it is deemed to have been tendered or served. That is not there. So by the addressee at the expiry of period normally taken by post in transit unless contrary is proved. So that's why we in our office always keep a track of it. See on the postal cover now try to ensure that you preserve the postal cover first thing. Ask the party, preserve it. There is a post number. Go on the portal. The information is available. Normally it's up to 3 months. So immediately first thing is go in and take the tracking and download and preserve it. It will give you absolutely correct tracking of that. When it was tendered and when it is delivered. All the moments have been described. That will help you for determining the date. Okay. No such deeming provision existed in the earlier this thing. Earlier it is date of service and service means received. Unless it is received, it is not served. That was the old law. Now it is not like that, so we have to be very careful to that extent. So served and received, this is a difference. There are quite a few good number of decisions on this. With this, we are done with the first case study. We'll go ahead with the second part of it. There is a person called Mr. Poor, uh, whose case was selected for scrutiny ASMT 10. Some other co-faculty will take. DRC 01 thereafter is issued, and ultimately SCN come. No reply was filed. Okay. Hence the order was passed upholding the demand. It is ex parte. 5th August 23, the order was passed. The PQR was not aware of such order. Okay. So, actually, it is not PQR, it should be poor. But I said, no, you should know where to cut and where to paste. So, I also am learning to that extent. So, here it should be PQR. And poor thereafter received the recovery notice on 15 February 24. Because there was no reply, nobody appeared, nobody heard. The order was there, no action is taken. So department has started recovery notice and attached his bank account. It is after how many days? 5th August was the order and 15 February, so almost 6 months. Okay. This is when Mr. Poor came to know that his bank account is attached and such order was passed. Because when bank attached, तो नाक बंद करेगा तो ही मुंह खुलेगा, ठीक है? So then bank account बंद कर दिया, then he realized what has gone wrong. Now the question here is, Poor filed an appeal before commissioner thereafter, and appeal was filed on 20 March. Okay. I think you remember the date, huh? His attachment happened in February. Order was in August and he filed appeal in March. Okay. Poor received PH, that is personal hearing notice, requiring explanation why the appeal should not be rejected on the ground of file beyond time limit, 3 months time. कंडोनेशन पीरियड 1 month पावर ओके टू द कमिश्नर 4 महीना हो गया अभी इधर 4 महीने कैसे काउंट करेंगे तो पोर्टल पे ऑलरेडी अपलोडेड इन अगस्त सो इट्स ऑलरेडी ओवर इन डिसंबर इटसेल्फ फेब्रुअरी मार्च इज फाइलिंग ओके सो पुअर सीक्स योर एडवाइस व्हाट टू डू कैन यू टेल मी एनी एडवाइस व्हाट वी कैन गिव क्या एडवाइस देंगे यू आर नॉट गोइंग टू गेट फीस ही इज पुअर बोलो फाइल द वेरी गुड रिट नो first of all, this session, how long I can take? Because RIT is different chapter. That's why 6 o'clock. See, I had to ask him because they have given momentum, no? So I had to stick to the time. So RIT is concerned, sir. First of all, I'll take only 1 minute. RIT can be filed only when you are challenging some notification, circular, or provisions. Are you challenging? Which section you are challenging? Which notification you are challenging? Which period you are challenging? Any? So that is not a section. This is a fact. So that is you cannot file writ against it. Yes. Yes. So what natural justice you want, sir? Your portal. You have got all the time to reply on WhatsApp in 1 minute, but no time to look at your for 6 months. Told me give the practical aspect. So since that is at the down, but since your question came, uh, whenever you are drafting any reply, appearing, tribunal, first appeal, whichever place, सर जजमेंट है ना वो इंजन का फर्स्ट है ना जजमेंट इज अ गार्ड लास्ट उसको नहीं लाने का पहले द डे यू स्टार्ट जजमेंट नो 99% ऑर्डर विल सी आई टेल यू वन वेरी क्लियर थिंग just try to understand anyway I may be wrong but he told me you share your experience so I am sharing my experience suppose you are quoting a judgment and you are appearing before me I may be commissioner whosoever and you are quoting a judgment which is given by Jinit and suppose he is a tribunal member judge so we first of all, every judgment, there has to be peculiar facts, your documentation, your reply, grounds of argument, these, that, lot of things. It may or may not be same. Two biscuits are not same, Parle and Britannia. It's very difficult to digest two facts are same. But it happens sometimes. So if you are, before explaining anything, you are telling, वो जिनित ने बोल दिया ट्रिब्यूनल ने इस पे माफ कर दो. Then I'll tell you, bloody, कौन है? Who is जिनित? अरे भाई तुम्हारा केस बताओ ना पहले. This is what is my ego get hurt. You got my point, sir. We are deep friends, so we are just see what he is a knowledgeable, respectable. I don't disrespect him, but what you are telling, instead of telling the facts, grounds, कुछ नहीं जिनित ने बोल दिया इस पे कुछ नहीं होता है. Who is जिनित? You got my point. So who is Mumbai Tribunal? तो मैं कचरा है इसका मतलब कमिश्नर. This is what happens. So please don't quote your judgment. Judgment है ना वो 60 पैरा लिखते हैं ना 56 के बाद चालू करो. ठीक है? Okay. Anybody else? What is recourse? Yes, sir. हाँ, natural justice is not given. दिया ना, PH दिया ना, नहीं दिया ना, you didn't appear. मैं शोकस में बोला you didn't appear. शोकस दिया आपको. हाँ, एक्सपर्टी हो गया आपका. सी व्हाट इज नेचुरल जस्टिस? अपॉर्चुनिटी इज नॉट गिवन. बराबर ना. आपको एसएमटी 3 दिया, आप सोया था. हाँ तो दिया ना, ये लो, ये रहा, ये रहा. सेकंड लाइन पढ़ो. देखो DRC 01 was uploaded on the portal. और सेकंड लाइन पढ़ो. हाँ तो यानी आपको क्या घर में आके लेके जाएगा क्या? नो सर, 1 मिनट. शोकस नोटिस है, आपने पढ़ा है शोकस को? उसमें 30 डेज का मैक्सिमम टाइम लॉ में लिखा है ना सर. तो अभी देखो शोकस आपको दिया है, उसके बाद में इसने लिखा है इन अ स्टिपुलेटेड टाइम. इसका मतलब 30 दिन हो गया है. सर अभी एक बात बताइए कि ये WRC का सेमिनार है, 4:30 का टाइम है, 4:30 से 6, आप 5:45 को आते हैं, बोलते हैं वापस चालू करो, मेरे को सुनने को नहीं मिला, पैसा दिया है. आई एम सॉरी. सो यू टेल मी. सर डोंट टेक इट अदर वे. आई एम लर्निंग, डोंट वरी, वी आर जस्ट शेयरिंग. आप हंस रहे तो चलेगा, लेकिन हम दोनों सीख रहे. तो सर ट्राई टू अंडरस्टैंड. एज ए ऑफिसर, सपोज यू आर ऑफिसर और माई क्लाइंट, चलो यू आर ऑन ड्राइविंग सीट. अभी आपने 30 दिन दिया तो लॉ आपने कंप्लेंट किया ना. यू हैव गिवन 30 डेज टाइम टू मी. अभी मैंने 30 दिन में दो पॉसिबिलिटी है. या तो मैं जवाब दे सकता है, नहीं दे सकता है. नहीं दे सकने का कुछ रीजन है तो टाइम मांग सकता है. टाइम मांग सकते हैं ना. तो आपने वो भी नहीं किया ना. फैक्ट में किधर है? तो आप तो सर बिग बॉस है, आपको कोई इंटरेस्ट ही नहीं है. हाँ, 1 मिनट मार्क योर वर्ड. अपॉर्चुनिटी और नॉट गिवन. तो फैक्ट इज डिफरेंट. इसलिए मैं बोला जजमेंट मत लेके आओ. तो अपॉर्चुनिटी इज गिवन ना सर. हाँ. सो इफ यू गिवन द अपॉर्चुनिटी ना, वो जजमेंट का फैक्ट बदल गया. सर ऑल ऑफ यू प्लीज टेक इट लाइटली. हम भी ऐसे ही सीखे, गिर के ही आदमी साइकिल चलाना सीखता है. ठीक है. तो द नेक्स्ट इज इन दिस नाउ व्हाट इज द एडवाइस वी हैव टू गिव. फर्स्ट ऑफ ऑल लेट. हाँ बोलो. हाँ, वो तो किया ना, कंडोनेशन ऑफ डीले के बाद ही रिजेक्ट किया आपका. बोलो. The condonation you have filed, that is a proper thing you have done, but I am not convinced on this. I am telling you, मैं आपको PS दिया है, उसमें लिखता हूँ मैं तुम्हारा रिजेक्ट कर रहा हूँ. Now you tell me डिफेंस. डिफेंस में CO, it's okay. ग्राउंड क्या है तुम्हारा डिफेंस का? I am not convinced. सर the approach itself shows that you are careless. तुमको ASMT 10 से अपील तक कोई टाइम नहीं, इंटरेस्ट नहीं है. ठीक है ना. सर अभी हमें ना सर, मोदी जी ना, जो हमारे कोरोना आया था ना, तो वो बेचारा दिल्ली में बैठ के 100 करोड़ को जो वैक्सीन देने के लिए अनाउंस कर रहा है. फिर आप बोलेगा सेंटर लगाने का इधर, फिर मेरे को घर पे आके कार भेज के लेके जाने का उधर, उधर ले जाके वापस घर में रख के आने का. सर यू आर एक्सपेक्टिंग लाइक दैट? नहीं, अभी वो आदमी क्या, आप PM रहेगा तो क्या करेगा? अभी आप कमिश्नर तो आप क्या करेगा? मेरे घर पे आके बोलेगा अरे भाई नोटिस आया, तुम जवाब दो यार. ऐसे नहीं होगा ना. सो पोर्टल दिया ना, पोर्टल का ऑफिस 107 पे लिखा है ना. करेक्ट. सो इफ यू आर वेरी गुड. I think, sir, this practical aspect of happiness will give better than. Sir, ऐसा मत ये कीजिए. See, at the end of the day, you try to understand कि the person before we are arguing ना, whether it is superintendent or Supreme Court judge, हाँ, you are one step down. भी ज्यादा हो सकता है, एक्सपीरियंस भी ज्यादा हो सकता है, तो हमारे सबके पास है, फिर भी हम देश के नेता नहीं है क्योंकि पावर ज्यादा है. ठीक है ना. तो उनके पास ज्यादा है, इस तरह से बात मत कीजिएगा. मीन्स नहीं कर सकते. तो the most important thing I have seen many time in my office, my juniors also, सर उसका ये फॉल्ट है. अरे साला तुम एक उंगली उधर कर, 3 उंगली इधर है, तुम्हारा फॉल्ट किधर है वो दिखाओ पहले. फिर योर फॉल्ट आपको नहीं दिखता है, उसका एक फॉल्ट है. अपॉर्चुनिटी तुम 4 बार में एक भी रिप्लाई नहीं दिया. एनीवे, नाउ विल कम ऑन टू दिस पॉइंट. सो डोंट टेक, इवन इफ ही इज एट फॉल्ट ना, ऑन दैट डे उसका शादी है बॉस, आपको रिस्पेक्ट देना है. ठीक है. तो देन द क्वेश्चन कम्स हियर इज, नाउ गो टू 107. नहीं वो हम लोग तो पता नहीं जिनित क्या बोलता है, मैं तो माई लॉर्ड बोलता हूँ, कोई भी होने दो. उधर जाके माई लॉर्ड बोलना पड़ता है. दैट डे इज लॉर्ड, केबिन के बाद फिर इज लॉर्ड, मे बी वट एवर. सी 107, what the law says, within 3 months you have to reply. Okay, that You have to give a reason. And cost for sufficient cost. Sufficient. What is sufficient? I will decide. You don't decide because I am authority. Okay. See, even if I am convinced ना, तुमने और कोई जुगाड़ कर लिया, प्रैक्टिकल रास्ता निकाल लिया, हाँ, और मेरे साथ अच्छा सेटलमेंट कर लिया, फिर भी मैं नहीं कर सकता हूँ, because 1 month है, okay, so I have some limitation and power. Now in that scenario where 3 months plus 1 month are over, now what to do? So what you should do it? Somebody told judgment. Yes, that judgment is right, but why that judgment, fact, etc. You have to come. No, there are two things. One is on this there are so many decisions, and few are on this side, few are on this side. If you read both, no, I think आज आपका आज का पोजीशन अच्छा है कि आपको कुछ पता ही नहीं है. जब आप दोनों पढ़ लेंगे ना तो क्या or come in your favor to that extent in spite your genuine cause, then you go to Limitation Act and try to fit into that section 5 and justify that there can be a reasonable cause, there can be very reasonable cause, okay, but वो reasonable cause 4 महीने में क्यों नहीं हो पा रहा है, इसके लिए मेरा टाइम आगे चला गया, that you justify, and these are the decisions for that, okay, then Limitation Act will survive. It is, there is no straight jacket formula. This word is being used 3 times in this decision of Singhi, straight jacket formula word, okay. Now we'll take Singh Enterprise Supreme Court decision. This is okay. See, considering the time, no, every fact if I know it, but I'm the crux, there are 5 or 6 decisions. Within the decision also there are contradictions. So because of the facts are different. Okay, so you be careful on that. Now here it has happened is that it was held at CCA appeal. So our case, this CCA appeal means old days. Now it is first appeal. Also the tribunal, both being the creature of the statute, are vested with jurisdiction to condone the delay beyond the permissible period. They say that beyond permissible period कर सकते हैं. Actually, I have not yet able to understand because commissioner of appeal is not a jurisdiction person. He is an executive. Executive has to follow the law only. Even if he has favor want to give, then also he cannot do. But this decision says so. Supreme Court is right because he has, the decision is not reversed. Okay, provided under the statute. The language used makes the provision clear that the legislature intend the appellate authority to entertain the appeal by condoning 30 days delay. आज भी 30 days ही है, 1 month. After expiry of 60 days, today it is 3 months. So this service tax में 60 days, which is the normal period for preferring the appeal. So today we have 3 plus 1. Okay. Now in this case, learned counsel for the appellant has emphasized on certain decisions, more particularly ITC case, which is a landmark case, to contend that High Court and this court, in the appropriate case, can condone the delay on sufficient cause shown. Not all the cause, sufficient cause. Sufficient means convincing. Now, sufficient cause in an expression which is found in a various statute. Okay. What is sufficient? It may differ from person to person, circumstances to circumstances. Okay. It essentially means adequate and enough. Looking at that fact, there cannot be any straight jacket formula for accepting or rejecting the application explanation furnished for delay cause in taking the steps. The cause for delay in filing instant appeal has not acceptable. That means what has happened is in Singh Enterprise they say we have power but we will not because we are not convinced with your fact of the case and cause. So what is coming out is that High Court, Supreme Court has a power and they say even tribunal can do it, but only when sufficient cause is given and if they are convinced. In this case, it is not done. So that means what is the outcome? Outcome is condonation was not accepted in this case, but they never said that we have no power to condone. We can condone provided you give sufficient cause. I hope it's clear to that extent. The next is there is a contrary decision, that is Delhi Stat Jagdish Ispat. Here it has been held that unless and until there is a statutory mandate means section, of extending the prescribed period to a particular number of days, the section 5 of NHL will be applicable. Now, there is a mandate for extending the period. तो हमारे इसमें mandate है 3 months plus 1 month. Section 5 of the Limitation Act will be applicable means what he is trying to say that come what may be, section 5 will be applicable to you. So it is saying overriding. I don't think this is a correct decision with due respect to the tribunal, because I will say that only in a specific circumstances you can go it. In all case 5 will not override the section 107, but anyway courts are always right unless it is decision is reversed. Okay. Now comes to section 29 of the Limitation Act, which says that it reads the position that even for a special law, okay, in absence of specific provision for extending the prescribed time but for a particular limit, that means in our case is also 30 days, okay, section 4 and 24, 4 to 24 of Limitation Act only will be applicable. That means it's a GST Limitation Act only will survive. Supreme, somebody said that it is supreme. This decision is in his favor. I'm not convinced with it to that extent. But Commissioner Appeal has no option but to dismiss the appeal, being a time barred, as the delay was more than 30 days. In our case, also it is. But keeping in view the power of this tribunal, this was tribunal. Our case, it is a commissioner. Huh? So they said tribunal can do it, and that the delay is attributable to the counsel of the appellant. Here, what has happened? No, they have given the case to counsel. The counsel could not file in time for maybe वो sick होगा या उसका फीस नहीं मिलेगा जो भी होगा उसने नहीं किया है. क्लाइंट बोला कि मैं क्या करेगा उसने फाइल नहीं किया है सो बिकॉज ऑफ द काउंसिल्स डिले दैट हैज हैपेंड दैट्स व्हाई ट्राइब्यूनल हैज कंडोन्ड see he said that I'm a assessee, what is my job, I want advice from doctor, so in your case whosoever advocate C is there, I have given the paper that is proved that person has not filed. So अभी इसके वजह से मैं क्यों ये करो तो then tribunal was convinced. Now whether it is right wrong that forget, at that point of time based on the argument tribunal was convinced and that's why it was given. Okay, now we will go to the next, that is Sambhu synthetics. To that extent, Sambhu synthetics, it was held that category that any delay beyond 30 days after expiry of 60 days, in our case 90 days, cannot be condoned since statute does not permit. You look at the decision, that was also Delhi tribunal, this is also Delhi tribunal. Same tribunal, different bench of course and different time. And the provision of 5 limitation would not apply. That means it says that Limitation Act हमारे इसमें आएगा नहीं because there is a specific provision. That is what is a Sambhu synthetics. Okay. Now further it says that decision of Supreme Court in the case of Singh Enterprise, which you have heard, is a binding. The decision of tribunal in Jagdish Ispat does not lay down good law. That is what Sambhu synthetic says. It says that Supreme Court decision was right and it is not right but it is binding. Right तो वो भी नहीं बोल रहा, binding. And the earlier decision which was given of Jagdish is not a good law. Same tribunal says. Tribunal does not have any power, much discretionary, less discretionary power to condone the delay beyond extended period of 30 days. So here this is one step ahead. Forget commissioner. Tribunal also has no power. That's what this particular case Shambhu says. Now we'll go to the next. Albert Company. It has been specifically held by Supreme Court while interpreting section 85.3, that is Finance Act, Service Tax. Okay. That the tribunal has no power to extend the period of limitation. So this is on the line of Shambhu. Okay. अभी 4 डिसीजन हो गया. बाद में आपको क्या समझाओ मेरे को बोलना, मेरे को तो कुछ नहीं समझा. Okay. The next is TNet messaging. This is Mumbai tribunal. The earlier was delay. It was held that it is well settled that once the period of limitation expires under 85.3, that is tribunal, neither tribunal nor first appellate authority has power to condone the delay. This is Mumbai tribunal in the year 2023, last year only. Okay. Now Allahabad High Court, in the case of Shailendra, while allowing the hearing of a writ, has accepted the argument of counsel that if the remedy of appeal is held to be non-existence, still jurisdiction of a writ court against the original order date so and so may not be hosted. That means where it has been stated that somebody told about writ. Yes. So it says, this court says that if somebody wants a remedy, he is trapped and he feels there is an injustice only because of time and there is no possibility to come out and for admission of appeal, he can go to writ and it is admitted. I am also not convinced on this because there is nothing has been challenged. There is no section, no circular, etc. What I am challenging is the action, and that action is also not in contrast to the law. So in such case, but anyway, court's decision is ultimately final unless reversed. Then last is Andhra Pradesh High Court, iron and metal case. It was held that while considering the application for condonation, it is not, this is very, very important, underline, it is not the length of delay, but cause of delay, which would be paramount consideration. See, at the end of the day, how many days delay, 1 year or 1 day, is not relevant. What is the cause? Okay, cause doesn't mean amount. The reason for delay. If somebody is hospitalized for 4 months, demand is only 500 rupees. Can you say, अरे छोड़ो ना भर डालो 500, अरे वो हॉस्पिटल में कैसा करेगा? So that is a genuine cause. And even if demand is 100 crore, but this person is enjoying IPL every day, 4 महीना छुट्टी लेके, ठीक है? So that is not a genuine cause. I am just giving extreme examples, but that means you have to case that you have to justify. So that is what is observed by Andhra Pradesh High Court. Okay, if the cause shown under 1074 of the Act, such delay deserve to be condoned irrespective of the length of the delay. Okay, It does not mean that the commissioner appeal can condone the delay beyond condonable period of 1 month after expiry of 3 months. And the Andhra Pradesh High Court says that commissioner himself can do it. Now, again, I am, every decision, ek aadmi hai, everybody is tribunal and High Court and Supreme Court also. So, which is right, I don't know. The right of the appeal, which is created under statute, is a substantive right of party that cannot be denied by taking a pedantic view. Okay. Then the last one slide, and then we'll close this part of the case study. Mumbai Tribunal in the Vishal Bidcon. This is a very recent decision, 2024, and this is a divisional bench. Okay, it was held at a maximum period within which the commissioner can entertain an appeal. Is 3 months, that is 2 plus 1 month service tax. Now it is 3 plus 1. As in the present case, appeal has been filed by the appellant beyond the prescribed time. There is no legal provision under which the commissioner can condone. Commissioner to nahi kar sakta hai. That is what 24 mein tribunal says. While considering this, they have taken all the other decision which has been argued by the counsel as well as the respondent. Supreme Court in Singh Enterprise, ultimately they relied upon Singh Enterprise, which is Supreme Court. Here it is held, they said that even though dismiss the appeal file, because that was dismissed by Supreme Court because they were not happy with the cause. They never say you have no power. They say your justification is not right. However, has held that the commissioner appeal and the tribunal being the creature of the statute vested with the jurisdiction to condone the delay beyond the permissible as provided under the respective statute. Those days finance act. Further, it was also held that there cannot be any straitjacket formula for accepting or rejecting the explanation furnished for delay caused in taking steps, and it has to be decided on the merit of the case after taking note of a particular background of the facts of the each case. Well, friend, the other part I am not reading on this. Now, ultimately, we have to conclude what is to be done. See, I have taken few decisions, few I have not taken. Okay, I think you will not find all the decision giving direction in same thing. Somebody say this is possible, this is possible, this is possible. Now, what is possible at the end of the day when client comes to us? So, I personally feel based on this, the more important is concerned Article 226 of the Constitution, and this is somebody is interested. This Panoli Intermediate is a very important decision of Gujarat High Court. Mumbai Tribunal is very recent. That also you can read. Petition under Article 226 would not lie for the purpose of condonation of delay in filing the appeal. That is Mumbai High Court. Somebody has said a writ to be filed. So Gujarat High Court say you don't come to us for by filing the writ. Okay, go by the normal this thing. In nutshell, in case of delay beyond 4 months, okay, if you want to be a sure shot foolproof and all, in my view it is always advisable to go to writ court, but not by way of a writ. You have to go to high court to that extent. Take the advantage of this thing and say that in the statute there is no direct provision, so commissioner appeal has no condonation power to that extent. He is executive bound by the law. Of course, some decisions says yes, some decisions says no, and justify the reasoning why there was a delay with the facts of the case and evidences, and look for this thing from High Court. That's one. However, looking at the two decisions which has come very recently in Mumbai Tribunal, there is a possibility for you to get a relief at tribunal because it has been given. Unfortunately, today in GST we have no tribunal, and you cannot wait long for tribunal. Once tribunal come, you have a choice either to go to this thing. If I am a consultant, I will try to go to High Court. Okay, although bit costly to that extent, but High Court is concerned, certainly it is not executive, it's a judicial this thing, and they will give importance to Limitation Act as against GST Act. So to that extent, the chances are bright. I hope I could able to throw light to the extent I understand, but I have given a different decision. You can take call on this part of it. So in our and I'm sure many of us will, because we have come across so many orders for which there is a delay has happened, and that's why this is very important for you. Yes, sir. Adjudicate 3 months plus 1 month extension. No, you're talking about the form? No, DRC 01 show cause, then order will come. Sorry? That's an order. That's an order. That fine. No, you are. What is the question? Time limit for filing appeal? First appeal, I told you 3 months plus 1 month delay condonation. Second appeal, tribunal 3 months plus 3 months condonation delay. Okay. Now, this is what about tribunal. Tribunal only one slide, because as on today we have know this thing. Not much known to me also, as on today it is not formed. But the provision is very clear. You get 3 months time to file appeal. many orders have been passed because there is no tribunal, you could not file. And then there is a 3 months time which can be granted to you for the purpose of your condonation if at all there is a delay, etc. And more important here is uh, this point to ponder is appellate tribunal is constituted under Article 323B of the Constitution, and it has gone in separate rules. If you look at the CSTAT rules are there. You can see in the portal. Okay. Now, when CSTAT rule, everything is there. This form, this is the time limit. This you have to do, and it was under Article 323B. Now, our GST is not under Article 323B. So, the GST is concerned. Why GST is having the rules or the statute provisions to file a timeline? Of course, today the timeline of filing appeal to tribunal, I am talking about the service tax because GST tribunal is not there. The service tax tribunal rules are concerned and the service tax rules are concerned, both are matching. But suppose in the CSTAT, it has been stated rules that time limit is to file the appeal is 4 months, and the Finance Act said that is 2 months. Which will survive? I hope you are getting what I am saying. Under the service tax regime, the timeline for filing the appeal before first authority was 2 months, tribunal was 3 months. Okay, now we have got GST with 3 months, etc. And then we have a tribunal rules also, and tribunal is creation of the Constitution, Article 323B, and GST is not under this. So we have two rules, and if there is a difference between these two, which will survive? I am also trying to search the answer. As on today, there is no contradiction. But otherwise, why you have two rules? जब मेरा rule बना पड़ा है tribunal का, तो why you have separate rules in GST? Anyway, that is only point to ponder. As far as the section 112 is concerned in GST, anybody who is aggrieved by the first appeal authority has to file appeal within 3 months, but tribunal is not there. Then in that case, there is a circular being issued in Maharashtra. This is circular number of 2020 May that you need to intimate to the jurisdiction officer that within 15 days of the order that I am going to file appeal against this. Okay, so they will not do recovery. Now, if you look at this wording, now this is ridiculous. You just read it. Assessee are directed to file annexure 1. Okay, with the jurisdiction officer within 15 days from the date of communication of appeal order. Suppose I lost the appeal today, first appeal, and I want to file the tribunal law, I have to inform to the department within 15 days, intimating their intention to file the appeal against said order. Okay. Now you read. If such a declaration is not submitted within 15 days from the communication of said order, then it will be presumed that the taxpayer is not willing to file appeal against the order and recovery may be initiated. This is ridiculous nonsense. See, I'll tell you, मेरे को law ही जब 3 महीना बोला है तो who are you to say 15 days भैया? Circular cannot override the law. Law says 3 महीना है and I decide always on the last day. Who are you? See, forget why I government officer भी है टाइम बारिंग के दिन लास्ट दिन करते हैं ना ऑर्डर करते हैं ना तो वो भी लास्ट दिन ही कर रहे हैं तो हम भी कर रहे हैं तो क्या हो गया मैं एक बात बताऊं हमारे इंस्टीट्यूट बोलती है जस्ट 30th April इज लास्ट डेट ऑफ फीस जिनिस बोलेगा 1 तारीख को नहीं भरेगा रजिस्ट्रेशन कैंसिल अरे भैया इंस्टीट्यूट दे रहे तुम कौन है भैया 30 अप्रैल है तो 30 को भरूंगा ना रात को 11:59 में ठीक है ना सो नाउ वन सर्कुलर कम्स आउट एंड दे से वी विल स्टार्ट रिकवरी ब्लडी गो टू हेल ऐसा होगा ही नहीं सेकेंडली आई टेल यू 7 साल हो गया तुमको ट्रिब्यूनल फॉर्म करने को नहीं होता यू डोंट हैव शर्म नहीं है और हमारे पे तुम टाइम लगा दो व्हाट इज दिस एंड देन व्हाई दिस सर्कुलर व्हाई हाँ इफ यू वांट टू डू रिकवरी आई टेल यू मैं अपील फाइल नहीं भी करेगा ना यू कांट डू रिकवरी who are you intimating is a courtesy you put annexure 1 that is fine but you say it is not it is presumed that you don't want to file और उसमें तो 3 महीने का एक और 3 महीना कंडोनेशन पीरियड है और वो भी चला गया तो मैं हाईकोर्ट जाके भी कंडोन करके आएगा करेक्ट ना so this is circular is concerned nonsense but anyway today cart is ahead of bullock we know everywhere portal is immortal and that's why the law is behind these are the slide I have been asked to skip how to file the appeal that Ginit said they will teach you so I am skipping that the now we have about 8 to 10 minutes. These are those who are interested, they can read this, and if there is a mistake, you convey me. Now, filing of appeal against order not uploaded on the portal. Okay, I think that also we have discussed. So we will not go by this thing. Other points. This is very, very important, which organizers have told me to deal with. The hard copy of the appeal in form number GST APL in duplicate along with all annexure to be filed physically. अभी ये करना है कि नहीं करना है? See, first of all, in my view, if you are strictly interpreting the law, करने का जरूरत ही नहीं है. See, where it is in the law that you have to file hard copy and soft copy both? कुछ नहीं लिखा है. Law says that file on the soft form. When commissioner notify, follow that process. If it is not possible to file on portal, file physical. That means one out of these three, whichever applicable. Now department says that there is a circular of Maharashtra. Okay, other state may be hoga. You file within 7 days. So today I file within 7 days I have to file. And if I don't do, appeal is deemed to have not been filed. So मेरा appeal file ही नहीं होगा. This circular is bad, somebody has to challenge. And challenge में वो cost भी हो जाएगा. But there is a cost to us, no? So that's why. So now as a precaution, so I told you, no, every time you need not fight a war. Okay. So here in this case, legally it is incorrect, but just to avoid the hardship. Okay. तो मेनी टाइम हम लोग गाड़ी बराबर चलाते हैं, स्पीड भी बराबर होता है, फोटो आ जाता है, पैसा भर देते हैं, कुछ चैलेंज नहीं करते. अभी क्या करेगा, 1000 रुपया का 1000 रुपया, लेकिन फाइट करने का 5000 50,000 हो जाएगा. ठीक है ना. सो इट इज इनकरेक्ट. तो यहाँ भी ऐसा ही है, फिजिकल कॉपी दे दो, not because it is valid or legal, just to avoid the nuisance cost. That's all. But you please do it, please file it out. The second is copy of OIO to be certified by adjudicating authority or lawyer or public notary. This is very, very important. Huh? We have faced a lot of difficulty. I can name the officer, but I think I'll avoid all crows are black. Wherever you go in India, officers are same. So where CA, whether can CA can certify? That is very important issue. Order. Huh? Suppose you are filing the appeal. Now first thing, try to understand, if you are uploading on the portal, there is no need to certify the order because it is already there on the portal. And everything happens in soft. तो तुमको उसको attach भी करेंगे तो certify करने की जरूरत नहीं है. That is, there is a provision. Okay. Which is written here, seeing this thing. Rule 1083 said that self-certified copy. Self-certified means assessee, not CA. That they have to self-certify. Whosoever is a partner, director or whatever. Now, otherwise assume that in your case, portal is not working, not allowing, then you are filing physical. So that time you have to give out a copy. So who can certify? Yes. CA, lawyer, notary. Don't tell me the officer. Yes, officer can always do it. You can go and ask the officer, he will certify. Assume you are not going there. And what is the other option? Is it notary, advocate, CA, or anybody? Yes? Or self-certified? What is the provision of law? Self-certified only on portal is valid, I told. So physically may be self-certified. Okay. Yes, anybody else? What about CA? Can CA certify? Huh? Somebody raise. कहाँ से आवाज आ रहा है? हाँ, yes. नहीं, लेटर ऑफ अथॉरिटी, पावर ऑफ अटॉर्नी सब कुछ दे दिया. कैन यू सर्टिफाई? सीओपी है ना आपका? नहीं, देन कैन यू सर्टिफाई? नो. व्हाई? That, sorry, is it under scope of इसके बाद किसी का सही का जरूरत नहीं है. Practically for time, let us keep it aside. You say there may be a valid point to that extent, is fine. But suppose we have to give physically, they are not accepting your appeal, it is to be certified, and you as a chartered accountant is certified. Are they duty bound to accept or not to accept? हाँ, that is तो कोई भी करेगा तो लिखना पड़ेगा. So the our experience is concerned. First of all, tribunal is concerned is accepting. Service tax era, GST tribunal I am not aware of. High courts are concerned, no. It is only advocates. As regarding the appeals are concerned, we are finding in most of the cases CA certificate not permitted is said by this thing. They are not ready to accept. Some places they are accepting is fine. So try to ensure that we cannot certify. And the law also you read, it is a notary, departmental officer, lawyer. Okay, even if you are having COP, it will be high probability if somebody wants to reject, yes, because you have no authority, because the courts, tribunal to accept, it doesn't accept. I have in one of the case, I told that officer while going and filing the appeal, there is harassment. I said tribunal, तो क्या हो गया, हम नहीं लेंगे. See, these are example I'll quote you. Tribunal is much ahead of this thing. They say नहीं, tribunal में चलता है, इधर नहीं होगा. I'll give my example for this thing on a one bit on lighter side. I joined LLB at the age of 50. Okay. And gone to a college. I selected a college where nobody comes and nobody takes attendance so that I am free and I can do my work. So I have taken admission, and those days 59% in BCom. Nowadays, so 59 perhaps is the last. Okay, so there is a cutout percent 70%. Okay, so then we had to try for admissions. I had gone, नहीं देते फॉर्म ही नहीं देते, forget about admission, पहले फॉर्म ही नहीं देगा, so they have written 70 के ऊपर फॉर्म मिलेगा. And I had gone to principal and I told him, sir, this, and I want to do this. Oh, अच्छा, okay, but you don't have percentage. You have only 59%. We have 70. बोला, but sir, I am chartered. अब तो क्या हो गया? बीकॉम में थोड़ी 70 है तुम्हारे. So you got my point. So parameter is the 70 चाहिए तुम्हारा है ना. So same thing, ट्रिब्यूनल अलाउ करते जाने दो, हम लोग अलाउ नहीं करेंगे. So be careful to that extent. नोटरी करवा लो, या तो सुपरिटेंडेंट या उनसे ले लो सिग्नेचर. सीए का किया, आपका नसीब खराब है, लास्ट दिन रहेगा, नहीं बोलेगा तो यू हैव अ डिफिकल्टी. ठीक है. Then each page of APL to be signed. Please do it. APL में signature last page पे, every page please sign. Please sign. That is advisable. Since he has said me, tell me the practical part of it. Is that because many a time what happens, you go there, either you go, your PO or assistant, whosoever goes there, वो बोले इधर ये कट कर, ये कर, वो कर, तभी बोले सिग्नेचर लेके आओ. तो पहले ही सही करके रखो. सेकेंडली ऑफ पेजेस है ना, लूज में निकल के आगे पीछे वो भी नहीं चाहिए. सो गिव नंबरिंग एंड ऑल, बट प्लीज सही करो. ठीक है. Then court fee stamp 1 rupee. I think you are attaching on both. That is okay. Proper indexing. Please give index. The CGO building I had gone now without indexing not taken. तुम इतना फाइल लेके आए, इंडेक्स किधर है? So order important नहीं, अपील important, इंडेक्स चाहिए. तो ठीक है, फाइन. यू प्लीज एंश्योर यू डू. दिस आर ऑल प्रैक्टिकल पार्ट ऑफ इट. आई एम नॉट सेइंग लीगल. आप बोलेंगे किधर लिखा है, तो मेरे को भी नहीं मालूम है किधर लिखा है, बट दिस इज प्रैक्टिकल. प्रैक्टिकल का अंदर जो नहीं लिखा है करना है, उसी को प्रैक्टिकल बोलते हैं. ठीक है. जो next is a power of attorney versus letter of authority. Big challenge. Jinit also has knows about this thing. It's a story about it. So you tell me, when you go before officer and there are two clients you are appearing on the same day before same commissioner. One has given you power of attorney, other has given letter of authority. अभी I am commissioner, I am बोलेगा letter of authority नहीं लेगा तुम्हारा, you are not authorized. Now you tell me what is the difference between these two, and letter of authority is okay or no? This is a fact I am telling you. He is a witness to it. We have faced this, and these are all live issues. 100% Bombay, not outside Bombay. So between power of attorney and letter of authority क्या फर्क है, और दोनों वैलिड है कि नहीं? वो अंदर क्या लिखा है वो कोई पढ़ता नहीं, दोनों सेम ही हो सकता है. हेडिंग इज इंपॉर्टेंट. Yes. So see, I'll tell you, I have tried to find out law में मेरे को ऐसा कोई सेक्शन किधर कुछ पता नहीं चला. Then Google it. आज के जमाने में Google is right. Okay, so it has been stated in Google searching some of the important observation which we found. We said that letter authority work is concerned, it is for simple tasks. What is simple, God knows. It can be used for getting routine work. So I presume that appeal is not routine work for the time, and that is what perhaps the commissioner says. Okay, but when there is a big transaction, it is better to get a power. These are wording downloaded from this thing. You can search on net, you will get these kind of thing, because it sets out the manner in which activity has to be done, which is very important. Because in letter of authority, if you see inside, they will write, I authorize Mr. Jinit to do 1, 2, 3, 4, 10 things. Okay. Now, power of attorney may you have to mention what he has to do specifically for what purpose. So I'll tell you, my flat is to be sold. I give him power of attorney for deal, negotiation, signing document, registration, etc., etc., etc. So that is per, and normally power of attorneys are specific purpose power of attorney. There are general power of attorney also to that extent. So this is a difference. So letter of authority may or may not specify how the activity has to be carried out. So, but in the power of attorney, and it is to be notarized also, has a additional edge over the between these two. One of the commissioner has not accepted us for hearing because there was no power of attorney. Instead of that, there was a letter of authority. Only the solace was appeal was not dismissed. They have given the opportunity. Again, I have brought the power of attorney. It was everything was written same except heading, but then it was accepted. So be careful to that extent. Okay. So advisable to give power of attorney. These are a very, very important thing. Perhaps you'll learn. Then next, authorized representative. This is very interesting. Suppose I am a sole proprietor, chartered accountant. In my office, 4-5 appeals have been fixed hearing on the same day. So you cannot go to all the places. So I'll depute my assistant A, go and appear for hearing. Competent, knowledge, everything fine. Huh? No, I'll not say competent, capable and everything. But okay, but not qualified. Not qualified because what? She has passed inter, CA, final एक group बाकी है, whatever. Whatever, she knows everything. She has only drafted the appeal. Okay. And the letter of authority says that authorizing RJ Luthia, Rajiv Luthia and his office staff. Okay. It's a letter of authority, power of attorney is given. Then I give in my letterhead, today RJ Luthia, Mr. XYZ will appear on my behalf, on behalf of the firm. Whether this is valid or not. I hope you are getting. I am talking about the first appeal and show cause, not tribunal. Yes, yes. Delegate cannot delegate. Okay, okay. Your answer is right. Justification is not right. Yes, and it is. No, I have written Mr. ABC my staff specific उसका आई कार्ड फोटो आधार कार्ड सब लगा दिया अभी. I am sorry. Original power of attorney is given to me. I am giving this thing that today I am occupied with one hearing at Nariman Point. This is at Panvel. So I am deputing Mr. So and so to appear. We don't want adjournment. He will appear. He is XYZ, my employee. उसका आधार कार्ड. Yes. So assessee has not given. Assessee in his power of attorney has given me. You can appear either through you or employee. अभी. अच्छा एम्प्लॉय का नाम तो सर ऐसा है ना, आज अपील फाइल करेगा तो 2-3 साल में हियरिंग आएगा. हमारे इधर एम्प्लॉय 2-3 दिन के बाद चला जाता है. ठीक है. Yes, yes, I am not on lighter side. I am just saying. See, first of all, he is not allowed unless he is a qualified person. You look at that qualified person, there is a definition. So in that assessee himself, he is employee, his relative is mentioned, he is authorized representative. There is a chartered accountant, lawyer, and if he is my employee CA holding COP, then he can do it. CA not holding COP can be rejected. Advocate not holding sanat can be rejected. So I have to mention ABC CA holding COP, ABC advocate holding sanat, because sanat and COP empowers you as a legal representative. Firm may be authorized, you are not authorized, not allowed. In tribunal so it will not be there. In first appeal also be careful. और कभी कभी क्या हो जाएगा, आपका हियरिंग ले लेगा और ऑर्डर में रिजेक्शन में आ जाएगा कि everything fine but that authorized representative was not a valid authorized representative, order is against you. तो आप क्या करेंगे, there is no rectification. इनकम टैक्स जैसा 154 नहीं है इधर. ठीक है. दिस इज नॉट मिस्टेक अपेरेंट फ्रॉम रिकॉर्ड. ठीक है. द नेक्स्ट इज 5 minutes. The date of PH was scheduled on 25th April. लास्ट चांस. मैं कल का ही था. ओके. अभी लास्ट चांस है, क्या करना चाहिए? यू आर नॉट रेडी विथ एनीथिंग. See, take an example, extreme case. There is an appeal, file in time. First appeal, first PH, second PH. Nobody has bothered to appear for whatever reason. 23rd को लास्ट तो शाम को 6-7 बजे ऑफिस बंद होने का है. सर कल सुबह हियरिंग है एंड आपको देना है, और तभी मेरे को डॉक्यूमेंट मिला है. एंड 24th इज द लास्ट डेट. 24 is the date and this is the third chance. Now tell me what to do. Yes, this is practical problem I am telling you. And we have just done, actually I have done on 24th only. That's why the date is written 24th. Yes. What to do? I think you have not faced any such of issue. You are very lucky यार, तुम्हारा सब काम हो जाता है. See, in this scenario, if you get adjournment letter, it's okay. Yes. Sorry. कोई जरा हाथ ऊपर करके बोलो ना. हाँ. Yes. सर रिप्लाई अपील का जो बना है ना वही है. एडिशनल सबमिशन कुछ बनाने का है, बनाने को मिला नहीं है मेरे को. ठीक है. The additional reply बनाऊं नहीं बनाऊं, what am I to do? So suppose you have filed the appeal, सब कुछ you have done, क्या लिखा है वो भी मेरे को नहीं मालूम, because you came to me on 23rd night. 24th morning is my hearing. Now what as a consultant I have to do? I want from you sir. I could able to read what is there. उसके बाद मैं अंडरस्टैंड करेगा, डॉक्यूमेंट मंगाऊंगा, ड्राफ्टिंग करूंगा, सबमिट करूंगा. इतना टाइम पॉसिबल ही नहीं है. तो 24 को क्या करना है? दैट इज व्हाट एग्जैक्टली आई वांट फ्रॉम यू सर. हाँ. So what is genuine cause? So with a genuine cause, can the officer is duty bound to give you adjournment? Acha, assume that he is a absolute third grade person, not convinced by anything except one item which we is a practical part, but other I forget it. Yes. ठीक है. ये these are all practical solution you are giving. I appreciate. तुम हॉस्पिटल में लिख के सर्टिफिकेट दे सकते हो, बरोबर है. चलो ठीक है. Assume that मेरे को है ना ये सब, that is fine. Whether I have to appear, not appear, or give adjournment letter. Suppose you give that reason and I reject it. So what will happen? I reject. Is it not right on my part to reject that? I have given you first chance, second chance, third chance, you are hospitalized. That is your good luck, bad luck. Okay. But now what should I do? हाँ हाँ ओके एंड देन व्हाट टू डू कुछ आता ही नहीं मेरे को क्योंकि शाम को मिला है okay so the best part is there he is right to great extent appear and partly heard करना partly heard करके आओ नहीं तो दैट ऑफिसर सी हमारे गुजराती बोलते हैं मीठी छुरी ओके बात करने के टाइम में स्वीट रहते हैं बाद में कट होता है आपका बरोबर है दैट कमिश्नर ऑल्सो चाय पिलाते हैं सब पिलाते हैं जो सही आना चाहिए ऑर्डर वही बरोबर नहीं आता है ठीक है ना तो व्हाट यू शुड डू इज यू प्लीज गो एंड अपीयर ओके appear and you explain this is what and you tell him my lord I want to make another adjournment additional submission and ask him to write in proceeding sheet in that case it will not be dismissed for sure 100%. So make it partly heard. If you don't do it, if you are lucky, there will be adjournment. Otherwise, he is not duty bound. What may be your reason is because you are defaulter on first, second time. तीसरी बार हॉस्पिटल में गया वो अलग बात है पहले 2 बार किधर गया था आईपीएल में गया था नहीं चलेगा The next is due to ill health CA XYZ he could not appear before concerned officer यहाँ पे एक्चुअल भी बीमार था सर and therefore his office staff Mr. PQR appeared on behalf of concerned officer since he was holding power of attorney अभी उसको power of attorney दिया है See, somebody told me नाम नहीं लिखा है कुछ somebody just now told employee का अभी इसमें उसका नाम लिखा है so in that case no if he is not authorized person नाम लिखने से कुछ नहीं हो जाता he should be authorized also power of attorney में लिखा रहेगा राजीव लुथिया ही स्टाफ XYZ CA है क्या नहीं है एडवोकेट है नहीं है सनद नहीं है COP नहीं है not authorized नहीं चलेगा be careful the learned officer did not entertain PQR and inform him that he is not authorized representative because he doesn't fall in the definition of authorized representative. Be careful. Whether contention officer is correct, yes, in my view, legally. बाकी out of the way आपको जो भी practical रास्ता है छोड़ दो. Then authorized representative, this has been defined. And what is authorized representative? You read there. You please ensure you fall within that. In that, it is a regular employee of the assessee, not your employee. Advocate entitled to go to the court. That means sanad. And he is not debarred from practicing any court. So that is valid sanad. Chartered accountant, cost accountant, company hold COP. Okay, so that is one part of it. Retired officer of the department, not below the post. And the last, any person who has been authorized to act as a GST practitioner, which is defined in the statute. Not any. Apart from anybody else appears, no, he is not an authorized representative. Your appeal can be rejected. This can happen in extreme cases. And anything happen in GST, once you 10-20 appeal appear karega, you will come across all these issues. Okay. The next is director is signing. Okay. He writes Reliance Industry Director Mr. Jinit. He is signing. Abhi now whether this appeal is valid. Appeal में मैंने सही कर दिया और rubber stamp मार दिया. Now this appeal is filed and I as an officer say this appeal will be rejected. It is not signed by proper authorized person. Now he is a director. Okay. Whether he is authorized person. So how I know? So in that case, please give resolution. This is what exactly has happened in our case. ABC and company director is signing. And it was grounds, everything is fine. He said, but it is not signed by authorized person. The director is signing. Now, if you read in the portal, who is authorized person, this director's name is appearing in the portal. GST portal, ABC and company, Mr. A is a director. In appeal, we are not affixed the rubber stamp of the director then and resolution was not given. The office commissioner appeal has written, there is no board resolution authorizing it. So please give board resolution also. Otherwise, see what will happen now. For you, it will be cost. He will reject it and there is no rectification. So these are all the precautions. You must give board resolution apart from this whenever company is giving. Partnership में resolution नहीं होता, LLP में नहीं होता, but private and public limited, please give resolutions. Okay. The next is PH for CW was held on 20 April and author CAPQR appeared. These are all case which I have given. Ground. Okay. So this rule 26 2C is very, very important. This is the last part, then I am closing. It provides that in case of a company, this is rule 26, CEO or authorized signatory thereof shall be signed each document including return. Each document means appeal bhi aa gaya. CEO or the authorized signatory. Now that means CEO के लिए कोई जरूरत नहीं है. CEO is a blank. Now you tell me how I'll know that Jinit is CEO of Reliance. ऐसे इधर तो लिख कर नहीं आता ना CEO. So he has to give something. Okay, for that also because इसका appointment देना पड़ेगा. Or authorized signature में then give a board resolution. Please give it. Otherwise you'll have a tough time to that extent and you may face this. Other point, I'll take 1 minute of other and then we'll close. It is always advisable to file adjournment letter in case you are unable to appear. First या second या fourth कोई भी hearing होने दो. Please file adjournment letter. Nowadays things are very easy. You can upload on the portal also where possible. Send by email to that extent. Okay. Physical copy you give it. We try for all modes. If you don't try at least one mode with you. Last thing you forget the before that next day at least. It will help you a lot. If you missed out for whatever, please do it. तीन चांस देना है फर्स्ट टाइम में क्या जरूरत है दिस शो दैट यू आर सिंसियर यू नो यू आर ओबीडियंट यू आर रिक्वेस्टिंग इट विल प्लीज मैं ना इनको पूछ के बोलूंगा बंद करूँ तो इनको अच्छा लगेगा उनको पूछे बिना बंद करके चला गया लास्ट टाइम इसके बाद कभी बुलाएंगे ठीक है ना तो दैट इज वन कॉपी ऑफ लेजर फिनेंशियल स्टेटमेंट advisable to be submitted duly certified. Anything you give, financial statement and all, where CA is involved, maybe an audit, etc. Please give certified copy. There are some company not liable for audit. Okay, so there is no auditor. Now ask his income tax return, prepare somebody as per books of account. You didn't generate करके देना, please. Nowadays that you didn't also some officer checking. So you must generate CA certificate. You take it to the extent wherever you are certifying financial data related to that. But any other documents are there like invoice. One officer has given me the order. You have given everything, contract, everything, but the invoice was not signed. That's why they are not authenticate. Not authenticate. My invoice, अभी MTNL का bill आता है. It is a computer generated signature not required. You read that MTNL bill, old days. Okay. Now invoices are computer generated. Okay. So there is no signature. आप DMart में लो किधर authorized signature पीछे signature नहीं है ना. Anybody. I am just saying any shop. Here we have given this. Everything. He is not asking during hearing, but order में आ जाता है. Everything is fine, but your invoices no are not authorized. So we can't trust the invoices, and it was rejected. Be careful. These are all the small grounds in that the assessee will face a lot of unnecessary problem, and the matter will go to higher forum. Probably again it will happen. Remanded back, you will go down. तो एक रुपए का 3 रुपए खर्चा हो जाएगा. ठीक है? Can proper officer ask for additional detail? The last and thereafter I went up, which is very important. Suppose during hearing there is some allegation. Take a simple example that there is some service which I have provided to the government and that is not liable to tax. That is what the contention of the officer, of the assessee, and he has claimed some exemption under some notification. The show cause notice he didn't accept it. Or assume that at show cause level only adjudication is going on. Now, show cause there is an allegation, this is the turnover of yours to this party, you are liable to pay tax under so and so, so and so. So, recovery 73 में notice आ गया. And you are replying that this is a contract and it is being rendered to the government, this section, this, and that's why exempted. So that is your justification. I hope you understood on that part. See, now during my hearing, I had gone, I have explained, okay, now officer says कि this is fine, लेकिन मेरे को अभी 26 AS लेके आओ, IT का अकाउंट में इनकम टैक्स रिटर्न का पूरा लेके आओ, उधर क्या दिखा है, समथिंग एल्स को लेके आओ. अभी रिसेंटली दे आर सेइंग तुम्हारा प्रिंसिपल ने स्टैम्प नहीं कॉन्ट्रैक्ट पे बोले तो कॉन्ट्रैक्ट पे स्टैम्प ड्यूटी भरा कि नहीं. अभी कॉन्ट्रैक्ट का कंटेंट तो हम मालूम है लेकिन स्टैम्प ड्यूटी भरा कि नहीं वो देखिए लाइक दैट इफ दे आस्क. आई वांट टू आस्क टू क्वेश्चंस. During this process, can officer ask for any documents which required by him for adjudication? That's first thing. And if he can ask, are you duty bound to give it? That is the second. Yes, anybody? This is last. Yes. Yes, sir. So what is scope of show cause? Okay. So 26 AS, P&L, financial statement. He said, but मेरे को I want to know that. अच्छा stamp duty भरा कि नहीं contract पे? कॉन्ट्रैक्ट मिला है मेरे को. कॉन्ट्रैक्ट इज देयर. वो कॉन्ट्रैक्ट दिया है दैट इज गिवन बाय गवर्नमेंट. तो उस पे स्टैम्प ड्यूटी भरा कि नहीं मेरे को ले तो वो भरेगा गवर्नमेंट. मेरे को कैसे मालूम पड़ेगा. बट स्टिल कैन ही आस्क दैट. assume that that is a for him he feels relevant, sir. See, yes. Okay, so he can ask whatever document. Fine. Anybody else? So, sir, now just listen what he has said. I think what he said you could hear, I believe. He has called you for personal hearing and he asked for detail. That is what he said. Correct, no? Sir, personal hearing आपका है कि मेरा है? आप ऑफिसर है. Hearing आपका है कि मेरा है? अच्छा, what is mean by personal hearing? आप जरा उसको explain करो layman like what is hearing? What do you understand by hearing? Whatever I want to say. Yeah, you are officer. Okay. So hearing में मान सकता है आप. Hearing का मतलब सुनना होता है ऐसा नहीं. उसके लिए आपका परमिशन का जरूरत नहीं ना सर. अच्छा, मेरे को जो देना है उसमें भी आपका परमिशन का जरूरत नहीं ना. तो आपने मेरे को पीएच दिया है ना. तो पीएच का मतलब हियरिंग होता है. पर्सनल हियरिंग. पर्सनल मेरे को बुला के आप हियरिंग ले रहे हो. तो हियरिंग में आपका काम सुनना है ना सर. हाँ, तो आप क्यों मांग रहे हो? You want to know the document is fine. So that's why you have called me for hearing. So hearing is a intimation through which you can call document. That is what you want to say, na? Okay, fine. Yes, you agree to what he says. तो सर आप जीएसटी ऑफिसर है ना. तो आप हियरिंग तो लास्ट में आएगा. उसके पहले शोकॉज आएगा. शोकॉज के पहले समन्स होता है, इन्वेस्टिगेशन होता है, इंक्वायरी होता है. उस टाइम में आप क्या कर रहे थे? पूछ रहे थे क्या सुन रहे थे? पूछ रहे थे तो तभी भूल गए. अच्छा, तो अभी आप पूछ सकते. अच्छा, अथॉरिटी में कुछ भी कर सकते. वेरी गुड. एक्चुअली है ना, आप जो बोल रहे हैं वैसा हो रहा है एक्चुअली. हाँ, अभी हमको यही बोलना है कि वो सही है कि नहीं. ठीक है ना सर. हाँ, यस. लिटिल लाउडर मैडम. या आई टेल यू the service tax GST. First of all, little difference between service tax and GST. Service tax में there was something called self assessment and best judgment assessment was there. Self assessment में कुछ नहीं होता था. Whatever you declare is assessment. कुछ नहीं होता. Best judgment में when data is not available 72 invoke होता है. लेकिन बेस्ट जजमेंट का कभी ऑर्डर देखा है क्या? अभी मेरे का ऑर्डर किधर लॉ में ही नहीं है. आप कैसे देखा? मेरे को देखना है. अभी नेक्स्ट थिंग इज नहीं, आप मेरे को बताइए. मेरे को व्हाट आई एम टेलिंग, ट्राई टू अंडरस्टैंड व्हाट आई एम सेइंग. सर्विस टैक्स में कुछ भी रिकवर करना है उनको तो पहला शोको देना ही पड़ेगा. ओनली वन एक्सेप्शन वाज दैट यू हैव कलेक्टेड द टैक्स एंड नॉट पेड. If you have collected the tax rightly or wrongly and retained with you, I will recover without giving notice because you are a trustee of the government. Your duty is to collect and pay. But otherwise, anything I want to recover from you, there has to be show cause. Thereafter, there will be hearing and thereafter there will be order. Okay. In GST, you have a section start from 59 to 65. Those are all the assessment sections. Different type of assessment is there. That's why you have got ASMT 10 आता है, फिर DRC 01 आता है, उसके बाद DRC 1 आता है. बराबर है ना? नॉर्मली कभी कभी A1A नहीं आता है. इफ इट स्टार्ट फ्रॉम इन्वेस्टिगेशन तो डायरेक्ट ASMT 10 से शोकॉज भी आ सकता है. Now this assessment provision was not there in service tax. And then we have 73 74. E-way bill का 129 छोड़ दो. नॉर्मल का 73 74 में शोकॉज आएगा. Either of these two. ठीक है ना? Now, invariably in GST, leaving about that section 61 and all, the officer is doing adjudication. 73 74 आया तो adjudication बोला जाता है. असेसमेंट जो होता है जिसका इनकम टैक्स का बैकग्राउंड है 143(3), 142(1), ये जो भी सेक्शन है उधर एडजुडिकेशन नहीं है. देयर इज असेसमेंट. इनकम टैक्स में एडजुडिकेशन इज नॉट देयर. Service tax में assessment was not there except self assessment, and GST में assessment is there but limited. By and large, all of us are around 73 74. So 73 74 में adjudication and assessment में major differences. In one line में explain करना है तो question paper is 1 pager is assessment, question paper is 100 pages adjudication. इनकम टैक्स नोटिस 1-2 पेज का होता है. सर्विस टैक्स जीएसटी का नोटिस 5-10 पेज के ऊपर शुरू होता है. Now why? The difference is adjudication may suppose I am doing Gini's assessment and adjudication. Both I am doing it. Same here. In income tax as well as GST, I am the same officer. So I will tell income tax notice, your case is selected under section so and so. You are required to submit following detail. 1 to 10, 100, whatever. Okay. Thereafter he comes, gives, I'll tell, okay, now give another 100. Then third time another 100. I can call as many time as I want till the timeline is there for passing the order. This is what the assessment is. Because I want to assess his taxable income. Now when it comes to GST, GST में adjudication without allegation possible ही नहीं. You have to have allegation. Assessment में allegation नहीं होता है. आपका assessment order same income accept होके आता है ना. See, you have declared income of X amount. They have 100 paper called. He is either satisfied, whatever way you satisfy him, but same income is retained. बराबर है ना? कभी भी मेरे को असेसमेंट में नोटिस में आप बिताओ ऐसे लिखा है योर इनकम टैक्स रिटर्न फाइल इज 1 crore. In my view, it is 2 crore. I want to recover tax of 39 lakhs, including surcharge. ऐसा नोटिस पढ़ा है आपने कभी? नहीं पढ़ा है. जीएसटी में ऐसा नोटिस पढ़ा है आपने शो कॉस्ट का कि bring the detail of financial at 23-24. I want to find out what is the tax amount due from you, whatever. ऐसा कभी पढ़ा है? नहीं पढ़ा है. GST, it will start there. You have done this. This is turnover you declared. According to me, this is turnover. This is the reason for this turnover. This is the rate of tax and pay this much tax. Then interest 75, 50 section. Then pay the penalty, whichever section is there. Right. 122, whatever. So there is a allegation. The difference between assessment and adjudication is this. So I will tell if I have to allege in it, then I will tell you ऐसा मैं बोलूंगा ना तुमने चोरी किया है तो दैट इज नॉट एलिगेशन. मेरे को लिखना पड़ेगा क्या चोरी किया है. तो जिनित तुमने मेरा कार चोरी किया है तो भी नहीं चलेगा. कौन सा कार किया है तो बोलेगा सियाज कार किया. अच्छा ठीक है. देन आई हैव टू रेट मिस्टर जिनित स्टेइंग एट सो एंड सो you have stolen my this car and this is a show cause notice. Why you should not put behind bar. तो यहाँ पे ऐसा आ जाएगा this much tax is evaded. Why it should not be recovered. Now in that case this is called allegation. So when it comes to allegation, you as a person, your role is to justify only allegation. Okay. तो शो कॉज नोटिस के पहले जो भी पूछना है वो पूछ सकते हैं. डॉक्यूमेंट इसके लिए दे कॉल लेटर टू यू, इंक्वायरी लेटर, दे कॉल इंफॉर्मेशन, इन्वेस्टिगेशन, दे कैरी आउट सर्च, दे कॉल यू फॉर रिकॉर्डिंग स्टेटमेंट, इशू समन्स. बरोबर है ना. इतना सब चीज दिया है. वो उसको करना नहीं करना उसके ऊपर है. बट ऑप्शंस आर गिवन इन द लॉ. वो टाइम तुम सोता है कुछ नहीं करता है. ठीक है ना. उसके बाद बेस्ड ऑन दैट ऐसे एलिगेशन नहीं कर सकता है. यू हैव टू गिव justification why you came to this conclusion. I cannot say you are taxable 50 lakhs rupees per tax nahi bhara. So which 50 lakhs rupees, why, which section, everything I have to write down. And what is the documentary evidence? So uske base pe that he has to do. Having done it, show cause has been issued. Thereafter, no question can be asked related to that. No document can be asked. See, it is like setting of the question paper. एक बार क्वेश्चन पेपर सेट कर दिया ना उसके बाद एग्जामिनर ने सिर्फ आंसर चेक करना है. तुम फेल करो चलेगा लेकिन नया क्वेश्चन नहीं पूछ सकते. आपका क्वेश्चन कंफ्यूजिंग होने दो, क्लियर होने दो, नहीं होने दो, जो होने दो. मेरे को जो लिखना है मैं लिखूंगा. शोले का स्टोरी भी लिखूंगा. ठीक है. बट यू कैन नॉट आस्क मी. यू गॉट माय पॉइंट. दिस इज व्हाट इज द शो कॉज नोटिस. दिस इज व्हाट द एडजुडिकेशन इज. सो व्हेन वी गो देयर, department has alleged me you are liable this. So okay, I am justified. This is the reason. This document and this is the evidence. What is to be given, what is not to be given is my lookout. If you find they are not sufficient, pass order against me. Okay, you cannot ask the details. Abhi, this is what is a legal provision. Now when you come to practical part, तुमसे जो होता है वो कर लो. ऐसा आरटीओ को मैं भी नहीं बोलता हूँ. ठीक है ना. तो इतना तो हमारे में So one is what is law and what is practical aspect. Practical aspect. So while drafting, we also come across many of officers. I'll tell you recently one thing. We have already given hearing of one of the case on 6th February, 6th February 24. And he has issued one more notice for hearing. One more opportunity, last opportunity is given to you for appear on 3rd May. Actual notice है. अभी 6th February का I appeared now. In that I always had we have nothing more to add. Letter में लिख देते. अभी I have told nothing more to add. तो क्या hearing and where is last chance? मैंने already chance exhausted. So you got my point. मेरे को जो देना था दे दिया. अभी कुछ नहीं देना है मेरे को. तो मैं बोला था because you want something. So of course this is on a practical. अभी सर इट इज अ फॉल्ट ऑफ द ऑर्गेनाइजर. प्रैक्टिकल पार्ट बोलते हैं तो क्या करेंगे. ठीक है ना. सो इन दैट केस नाउ हाउ टू डू. तो यू हैव टू बी डिप्लोमेटिक टू दैट एक्सटेंट. हाँ चलो तो क्या करेंगे. बट ये फैक्ट है ना. तो वन पार्ट इज कंसर्न कि यू नीड टू बी इन दिस केस हैंडल डिप्लोमेटिकली. So we have written the reply, sir. We have already given the hearing. That was we don't want to add anything. Neither we want to submit anything. Consider our submission and adjudicate the order. This is one way. उसको कोई रियली डॉक्यूमेंट चाहिए और जो आपको लगता है रेलेवेंट है आप देखिए. nahi dena, but legally he cannot ask. That's all. I am sorry for extending my time. There is a lot more left out, but thank you very much. Hope whatever experience I shared, it is relevant to that extent. It may help you out to that extent. Thank you very much to WRC and all of you.
I request everyone to just give another 30 minutes, 30 seconds. Stay put, stay put, because the speaker deserves the vote of thanks. Well, sir, you really played well in the limited over time that was provided to you, and I'm sure everyone would agree over here. कि if some gentleman comes at 5:45 and tells you कि sir lecture वापस से चालू करो, we all would love to listen to you, sir. And friends, I agree that he did full justice to the topic. And sir, you did full justice to the momento as well, sir. And with your kind of knowledge and energy, WRC will अगले बार आपको 100% बुलाएंगे और momento भी देंगे, sir. I request everyone to carry out a huge round of applause for sir. Thank you, everyone. Thank you.